All right, we're going to follow up on Chapter 4, Section 4, the issue regarding the Francis G. Smith taking the fifth being an issue for FINRA, because I think this is incredibly important. Quick summary: a new lawsuit against FINRA highlights growing tensions between regulatory enforcement and constitutional protection, basically meaning who's more important, the Constitution or the association, right? On February 15th of 2025, Francis G. Smith of FGS Financial filed a complaint in the U.S. District Court of the District of Columbia, alleging that FINRA violated his due process rights. This lawsuit claims that during a probe into his continuing education compliance, FINRA demanded sworn testimony and warned Smith he could face expulsion from the securities industry if he asserted his Fifth Amendment right against self-incrimination. Now, this video is getting uploaded right now as we speak. Chapter 4, Section 4. So when I go back and look at it, the premise, from my understanding, is that you are allowed to step away and assert your Fifth Amendment privilege if you feel as though you're taking the stand to essentially self-incriminate, which he asserted his Fifth Amendment right against self-incrimination. He is allowed to do so, or he should be. So I'm going to do a little digging. Let's do a little research. I found his website here, Frank Smith, and we'll see what we can dig up. Frank G. Smith, president of FGS Financial, has been guiding individuals and families in achieving their financial goals. Since '92, beginning his career in financial services at Aid Association for Lutherans, a fraternal benefit society. Oh, that's fun. He transitioned in 2012 to an independent financial advisor role, founding FGS Financial. With over 3 decades of experience, Frank specializes in financial planning, retirement planning, college funding strats, estate planning, tax planning. In addition to leading FGS Financial, he has shared his expertise as an instructor, teaching adult education programs on key elements of financial well-being. Residing in St. James, New York, with his wife Heidi, Frank is dedicated. He's a dedicated family man. He has 2 children, his son Frank, who lives in Florida, with his 2 sons, and daughter Brandy, who is also a financial advisor at FGS Financial and resides in Babylon Village with her 2 sons. When Frank is not working, he and Heidi love to spend time outdoors, camping in their RV on the beaches in Long Island and at Lake George with their grandsons and rescued pups, Chance and Frida. Alright, I don't remember giving a fuck about any of that other stuff. But, so, let's go ahead and see what we can find with this guy. Because this is kind of huge. This is essentially allowing a financial advisor to be a financial advisor, or forcing them to kind of take shit that they're not supposed to take, forcing them to deal with stuff they shouldn't have to deal with. Yeah, I basically saw this already, so this is nothing new. What licenses does he have? Very limited information on this broker. Interesting. Doesn't mean much, but it doesn't not mean much. Francis Gerard Smith, is this our guy? Yeah, probably. Let's double check. I don't think this is our guy. Yeah, I don't think this is our guy. FINRA. That's not the company. Let's try to find his... What do we got here? This is 1969. Nope. Broker claims FINRA's testimony demands violate constitutional rights, which they do. Wants a temporary restraining order to stop FINRA from allegedly requiring on-the-record testimony without the protection of the Fifth Amendment, which he should be entitled to. This might be a different perspective. Let's read. A New York-based broker is suing FINRA over its demands for on-the-record testimony, claiming its calls amount to a subpoena without the benefits of the constitutional protection that come along with it. According to the complaint filed with blah, 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 we already saw this. Francis runs FGS Financial out of Setauket. He provides financial advisory services to about 385 households, manages $210 million in assets, taking in more than $100,000 in monthly commissions. Good for this guy. Fuck you. According to his broker check, Smith registered with Commonwealth. Oh, so that is him. Hold the phone. So that is him. Okay. So if this is him, what does he have? Commonwealth Financial Network. Commonwealth Financial Network. Who are these clowns? Okay, that's the investment advisor. Why? Computer, can you not give me such a hard time right now? Thanks. Can't do that for me? Cool. Cool. Who gives a fuck about copy paste, right? Anybody ever just want to break the fuck out of their computer sometimes? Okay. One self-regulated org. I'm guessing that's FINRA, 24 states, territories, blah, blah, blah. Yes. Oh, yeah, AAL. That was him. Okay, so he was out in Minneapolis. General Securities Rep. Invest in co-variable contracts. Okay. He's an agent. IAR. This was, what, 2021? Okay, so that's recent. He did his SIE. That should be Series 7. That should be 6. 63. This was in 92. Okay, so that's when he got his start. That's when he started jumping. Okay, fair enough. This dude's qualified. For now. Last March, FINRA investigators approached Smith concerning an ongoing investigation. He eventually retained counsel after learning he would have to give sworn testimony. Should have gotten counsel the moment they contacted him to say hello. According to the complaint, FINRA investigators, I don't know if you guys have ever had a stick of lavender just to smell. It smells great. According to the complaint, FINRA investigators told his counsel they were interested in his dealings with Wesley Triani. Okay, so this guy's registered as something as well. Oh, Bard. Big problems. Big problems. Okay, disclosure. What do we got? What do we got? Equity services. Okay, so this is... Okay. Regulatory final. So he was at this company for 20 years, Equity Services. Without admitting or denying the findings, Triani consented to the sanctions and to the entry of findings that he refused to provide documents and information requested by FINRA as part of its investigation into the circumstances giving rise to a Form 4535. What the fuck is that? 4530, I feel like that's important. FINRA Rule 4530 requires firms to report specified events quarterly statistical and summary information regarding written customer complaints, and copies of specified criminal and civil. Oh. Gotcha. FINRA Rule 4530, modeled after NASD, I'm assuming NASDAQ, and former New York Stock Exchange Rule 351. Any matter that becomes a subject to reporting or filing on or after July 1st must be reported or filed in accordance with the requirements of FINRA Rule 4530. Jeez. So, was this dude hiding something or trying to hide something? Requires firms to promptly report specified events to FINRA no later than 30 days after the firm knows or should have known of their existence. Fair. Requires a firm to report to FINRA within 30 days after the firm has concluded or reasonably should have concluded on its own that the firm or associated person of the firm has violated any securities, insurance, commodities, financial, or investment-related laws, rules, regulations, or standard conduct of any domestic or foreign regulatory body or self-regulatory orgs. Okay. Timeliness report card. Got it. Okay, so they get checked on this stuff. Okay. So he just didn't, without admitting or denying the findings. So this did he take his Fifth Amendment right? What the fuck was he doing? Triani consented to the sanction and to the entry of findings that he refused to provide documents and information requested by FINRA as part of its investigation into the circumstances giving rise to a Form 4530 filing. Uh-huh. So he got barred permanently. Wow. So he's out of the game. Jeez. Okay. So this AWC, this acceptance, waiver, and consent, is submitted on the condition that if accepted, FINRA will not bring any future action against respondent alleging violations based on the same factual findings described in this AWC. So this dude might be on some shit that he doesn't really want to be a part of. Department of Enforcement Financial Industry Regulation Authority. Acceptance and consent. Background. Triani first registered with FINRA in 2000. Since February of 2003. Triani has been registered as an investment company. Variable contracts, products rep through an association with Equity Services. Okay. Triani refused to provide documents and information requested pursuant to FINRA Rule 8210. What the fuck is FINRA Rule 8210? I wonder if FINRA's like, there's no cursing in videos. I'd be like, dude, FINRA, how about fuck off? How about that? Don't actually fuck off, FINRA. I need a job. 8210, provision of information and testimony and inspection and copying of books. Whoa. For the purpose of an investigation, complaint, examination, and proceeding authorized by FINRA bylaws or rules, an adjudicator or FINRA shall have the right to require a member, person associated with a member, or any other person subject to FINRA's jurisdiction to provide information orally, in writing, or electronically. The fuck does it have to do with anything? Inspect and copy the books, records, and accounts of such members or persons with respect to any matter involved in the investigation, complaint, examination, or proceeding that it is in such members or persons' possession, custody, or control. Whoops. So this is kind of just telling you they should be able to do whatever the fuck they want with your stuff. Is that what this is getting at? Establish programs for the submission of information to FINRA on a regular basis through a direct or indirect electronic interface between FINRA and its members. English, please. English. Okay, here we go. This rule requires FINRA members, associated persons, and persons subject to FINRA's jurisdiction to provide FINRA staff and adjudicators with requested books, records, and accounts. In specifying the books, records, and accounts of such members of per or person, a paragraph of the rule refers to books. Paragraph A of the rule refers to books, records, and accounts that the broker-dealer or its associated persons make or keep relating to its operation as a broker-dealer or relating to the person's association with the member. This includes but is not limited to records relating to a FINRA investigation of outside business activities, private securities transactions, or possible violations of just and equitable principles of trade, as well as other FINRA rules, MSRB rules, and the federal securities laws. It does not ordinarily include books and records that are in the possession, custody, or control of a member or associated person, but whose bona fide ownership is held by an independent third party and the records are unrelated to the business of the member. What? The rule requires, however, that FINRA records, that FINRA members, associated person, or person subject to FINRA's jurisdiction must make available its books, records, or accounts when these books, records, or accounts are in the possession of another person or entity, such as a professional service provider. But the FINRA member, associated person, or person subject to FINRA's jurisdiction control, or has a right to demand them. Okay. Seems very nitpicky. Basically just a way of saying we can grab your shit whenever we want it. Basically. Yeah. Rule 8210 authorizes FINRA to inspect and copy the books, records, accounts of a member firm with the respect to any matter involved in an investigation. So all they have to do is just, require it. Hey, we're investigating this guy. You don't want any problems. Open your doors to what we gotta check out. Got it. For purposes of Rule 8210, whether a particular document, blah 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 blah. A document will be considered to be in the control of a member firm or person if the firm or person has the legal right, authority, or ability to obtain the document upon demand. Dude, you know what I'm realizing? All the money in the world is not worth a shitty client. It's just not. You get a client who can work with you, who you can talk to, you can be open with. Not to say you can't be that with everybody. But when you want to help people, you should be able to know right off the bat whether or not they want to help themselves. You know what I mean? Like they should be looking for a financial advisor to advise them on how to find a solution to a problem they're having. Not someone who just wants to fucking float some money out and eventually start bitching and complaining about, well, this isn't done the way I wanted. I'm gonna have to go to FINRA. Jackass. All right, let's see what we got. Yes, Rule 8210 authorizes FINRA to obtain the expense reports from both the firm and the associated person. A member firm's books, records, and accounts include those documents that the member firm makes or keeps relating to its operations, as well as documents that the member firm makes or keeps relating to an associated person's association with the firm. So they're gonna track your shit, whether you like it or not. Okay, so that's what this is all about. Okay, first registered with FINRA in 2000 since Feb of 2003. Triani has been registered as an investment company and variable contract products rep through an association with. All right, we went through that. Overview. Tranny refused to provide documents and information requests pursuant to FINRA Rule 8210. As a result, he violated FINRA Rules 210 and 2010. The hell is 2010? So what I'm getting at here is this dude is just not being open with the regulators about his documents and his practice. And he's trying to get off easy somehow with that AMC or whatever the fuck he did. We'll go back to it. We'll check it out. Standards of commercial honor and principles of trade. A member in the conduct of its business shall observe high standards of commercial honor and just and equitable principles of trade. All right, basically, what? Just don't be a piece of shit. Yeah, just do right by your client. This is by Jenny Clark. FINRA Rule 2010 states that a member in the conduct of its business shall observe high standards of commercial honor and just and equitable principles of trade. Undoubtedly open to interpretation. Yeah, no shit. Yet the scope of Rule 210 is intentionally broad, equipping FINRA with flexibility to penalize bad conduct not specifically stated in other FINRA conduct rules. Wow. Wow. The seriousness of breaching FINRA Rule 2010, also known as FINRA Conduct Rule 2010, cannot be understated. We'll cover the implications of non-compliance of Rule 2010 later in this article. Wow. FINRA's Suitability Rule 2111 is distinct from the consensus. We're not here for that. FINRA regulates U.S. firms, a critical part of the securities industry, capital, blah, 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 blah. 3,378 securities firms and FINRA registered reps totaled 620,882. Wow. Members consist of broker-dealers, investment advisor reps, and dual-registered individuals. Huh. Firms and brokers must uphold respectable ethical business practices. Got it. Fair. Okay, so just know what you're doing, serve the public well, have a good ethical, moral grounding when it comes to your business dealings. I mean, obviously, we all, we're not perfect, but when FINRA comes, I mean, they should have the ability to say, hey, what you doing? Might need to pull it back a little, kid. All right, I agree. What are the consequences of non-compliance? Under the provision of Section 15A, the SEC, 1934, which later authorized the formation of the SEC, Joseph Kennedy was the head. FINRA possesses the authority to discipline its member firms and certain individuals for violations of securities laws and rules administered by FINRA. Yeah. They can impose fines, limit your business, bar you, expel you. Wow. So yeah, just, play by the rules. Don't be stupid. In 2021, what is this? Robinhood Financial was slammed for FINRA Rule 2010 violations in order to pay approximately $70 million for systematic supervisory failures and significant harm suffered by millions of customers. The sanctions represent the largest financial penalty ever ordered by FINRA. Ugh, jeez. That's rough. They penalized them 5% of their yearly revenue. Oh, jeez. Can't imagine how Robinhood's doing now. Probably went in the dump and went bankrupt and learned their lesson and never came back to the business. You know. In a statement related to arguably one of the most famous FINRA 210 cases, Jessica Hopper, EVP and head of FINRA's Department of Enforcement, said the fine imposed in this matter, the highest ever levied by FINRA, reflects the scope and seriousness of Robinhood's violation, including FINRA's finding that Robinhood had communicated false and misleading info to millions of its customers. What, like it's not rigged? Is that what they told their customers? Anyways. Alright, so this dude's just not complying with rules, not being open about shit, and he might be into some shady deals, according to FINRA. This matter originated from FINRA's review of a filing made by another FINRA member, firm pursuant to FINRA's Rule 4530. Here we fucking go. What's 30? What's this one? Okay, so this dude's just not submitting his documents. FINRA Rule 8210A1 states in relevant part that FINRA may require a person subject to FINRA's jurisdiction to provide information orally, in writing, or electronically with respect to any matter involved in a FINRA investigation or examination. Rule 8210C further states that no person shall fail to provide information pursuant to this rule. A violation of FINRA Rule 8210 is also a violation of FINRA Rule 2010, which requires member firms and their associated persons to observe high standards of commercial honor and just and equitable principles of trade in the conduct of their business. Yeah, just don't be a piece of shit. On July 21st, 2023, as part of its investigation into the circumstances giving rise to the Form 4530 filing, FINRA sent a request to Triani for the production of documents and information pursuant to FINRA Rule 8210. As stated during his counsel's phone call with FINRA on August 15, 2023, and by this agreement, Triani acknowledged that he received FINRA's request and will not produce the information or document. Wow. By refusing to produce the information or documents as required pursuant to FINRA Rule 8210, Triani violated FINRA Rule 8210 and 2010. So he just said no. He wasn't going to do it. And, okay, so that's what we have so far. Respondent also consents to the imposition of the following sanctions: a bar from associating with any FINRA member in all capacities. Wow. So you can't even talk to your guys or people in the business. Respondent understands that if he is barred or suspended from associating with any FINRA member, he becomes subject to a statutory disqualification, as that term is defined in Article 3, Section 4 of FINRA's bylaws, incorporating Section 3A39 of the SEC Act of 1934. Accordingly, he may not be associated with any FINRA member in any capacity, including clerical, ministerial functions, during the period of the bar or suspension. Okay. The sanction imposed in the AWC shall be effective on a date set by FINRA. A bar or expulsion shall become effective upon approval or acceptance of the AWC. Respondent specifically voluntarily waives the following rights granted under FINRA's Code of Procedure: to have a complaint issued specifying the allegations against him. He doesn't want that, okay. To be notified of the complaint and have the opportunity to answer the allegations in writing. He doesn't want that either. To defend against the allegations in a disciplinary hearing before a hearing panel. To have a written record of the hearing made and to have a written decision issued, and to appeal any such decision to the National Adjudicated Adjudicatory Council, and then to the U.S. SEC and the U.S. Court of Appeals. He doesn't want any of this. Okay. Further, respondent specifically and voluntarily waives any rights to claim bias or prejudgment of the chief legal officer, the NAC, or any member of the NAC in connection with such persons or bodies' participation in discussions regarding the terms and conditions of this AWC or other considerations of this AWC, including its acceptance or rejection. Respondent further specifically and voluntarily waives any right to claim that a person violated the ex parte prohibitions of FINRA Rule 9143. Wouldn't be doing my job if I didn't check. Got it. So this is kind of weird. He let me pull the micro close to me a little bit here. He doesn't want any of that stuff. But he probably, I don't know, was he into some shady shit maybe? You know, not reporting, not this is the wrong term, but exposing himself. I mean, you should be able to be open about your business practices, unless you're not wanting to be open about your business practices, and if you're not, chances are you're doing some shit, you know. Submissions of this AWC is voluntary and will not resolve this matter unless and until it has been reviewed and accepted by the NAC, a review subcommittee of the NAC, or the Office of Disciplinary Actions, pursuant to FINRA Rule 9216. If this AWC is not accepted, its submission will not be used as evidence to prove any of the allegations against respondent. But it has been accepted, allegedly. Correct? Or am I tripping? Where is it? Okay, if accepted. Got it. So, my initial gut instinct is that where there's smoke, there's fire with this guy, because the record has proven that he's not going to reveal what he's got going on. Now, is he doing anything illegal? I can't say. But I also can't say that he's not. If accepted, looking at Section C, if accepted, this AWC will become part of respondent's permanent disciplinary record, may be considered in any future action brought by FINRA or any other regulator against respondent. This AWC will be made available through FINRA's Public Disclosures Program in accordance with FINRA Rule 8313. FINRA may make a public announcement concerning this agreement and its subject matter in accordance with FINRA Rule 3313, and respondent may not take any action or make permit to be made any public statement, including in regulatory filings or otherwise, denying directly or indirectly any findings in this AWC, or create the impression that the AWC is without factual basis. So he can't even hint at the fact that it might just be a complete sham. He's just gonna have to go off the radar from here on out. Wow. Respondent may not take any position in any proceeding brought by or on behalf of FINRA, or to which FINRA is a party, that is inconsistent with any part of this AWC. Nothing in this provision affects respondent's right to take legal or factual positions in litigation or other legal proceedings in which FINRA is not party. Nothing in this provision affects respondent's testimonial obligations in any litigation or other legal proceedings. Dude, follow the fucking rules. Respondent certifies that he has read and understands all of the provisions of this AWC and has been given a full opportunity to ask questions about it. Respondent has agreed to the AWC's provision voluntarily, and no offer, threat, inducement, or promise of any kind, other than the terms set forth in this AWC, and the prospect of avoiding the issuance of a complaint has been made to induce him to submit this AWC. Jeez, dude. That's a whole fucking enchilada to unwrap. Jeez. Let's... Okay, so this dude is, we're not gonna judge off the rip. I don't know him. But, he's not fighting this at all. I mean, he's not even trying. Granted, he might have his reasons. And if that's the case, do your thing, obviously. But, yeah, this dude he's been in the game for, 22 years. I'm sure he has a nice 401k. I'm sure he's got good stuff in the bank. But, you would think if you had a good case, you would kind of fight this. You'd fight this a little bit, don't you think? So this dude's out of the business, essentially. And back to this Frank. We'll read this again. Last March, FINRA investigators approached Frank Smith concerning an ongoing investigation, and he eventually retained counsel after learning he would have to give sworn testimony. According to the complaint, FINRA investigators told his counsel they were interested in his dealings with Wesley. Oh. Now it's connecting. Okay. Who purportedly assisted financial advisors by complying with continuing educational requirements. What? Told his counsel they were interested in his dealings with Wesley Triani. Wesley Triani, who purportedly assisted financial advisors by complying with continuing education requirements. So, this dude is teaching. Is this dude teaching people off grid? If he's been out of the business for a year or a better part of it, where the fuck is he? Is he still in the loop trying to teach people how to be an advisor? This guy. Isn't this dude barred? I think that... Here we go. When I get to something juicy, I'll point it out for you. Can't listen to the whole interview. Get these clowns out of my face, man. Point is, he should have been out of the business, and for whatever reason, he might still be around. God knows what. According to an affidavit by Smith, he'd known Triani for about 20 years, but later became aware that Triani was part of the focus of a FINRA investigatory sweep. The agency settled charges with dozens of registrants, accusing them of falsely claiming they completed continuing education requirements for their state insurance license, when someone else, allegedly Triani, had done so on their behalf. The agency settled charges with dozens of registrants, accusing them of falsely claiming they'd completed continuing education requirements for their state insurance license when someone else had done so on their behalf. So they're claiming plagiarism. That's what this is. FINRA barred Triani from the industry in 2023 for failing to cooperate with the ongoing investigation. So was this dude just fucking taking bribes to take tests for other people? Is that what this fucker was doing? This dude snorting too much cocaine on the fucking... These dudes are doing too much drugs on the weekdays, at the weekends. They couldn't just sit down and study for a few hours. In his affidavit, Smith noted that many of his registrants named in FINRA settlements had been fired from their firms or were otherwise out of the industry. In short, should the investigation go wrong and an adverse finding is made against me, there is that you don't want to self-incriminate. It could have consequences that would be devastating to my career and FGS Financial. All I have worked so hard for would be destroyed. To be fair, Frank, and this is my perspective, I'm a kid and whatnot, but if you knew this fucker was barred and you know the rules, it's kind of on you. According to Smith, FINRA mandated on the record testimony alerting him to be sworn under oath when testifying, but that because FINRA is not a government agency, the Fifth Amendment privilege against self-incrimination does not apply in its investigations and proceedings. Smith argued that this was unfair. However, in the book, in my studies, let me just triple check this for you, because we just did section 4, chapter 4, section 4. Let me go back to that. It was around page. Yeah, here's section 4, chapter 4. Okay, let's go to the. Here we go. The administrators can compel testimony that incriminates. The administrators can compel any individual to testify, even if the testimony might tend to incriminate that person. This is permitted as long as the state's laws guarantee that the evidence cannot be used to prosecute the individual. Otherwise, that individual can use their Fifth Amendment right against self-incrimination to not testify. So, okay, so I think this dude is guilty. If, I know I'm jumping to conclusions there, but if this dude doesn't want to testify with regard to this Triani guy, it's probably because if he does, he'll incriminate himself, and if he does that, he can't take the Fifth Amendment. Or can he? This is permitted as long as the state law guarantees that the evidence cannot be used to prosecute that individual otherwise. Prosecute that individual. So, if he's in New York, then I'm not sure if New York is fully allowing him to kind of be open and honest about what he wants to say, because if he is open and honest about what he wants to say, I don't think he knows if he's guaranteed to have protection, that what he says is never going to come back to haunt him. So he's trying to use his Fifth Amendment right to not testify, which is, from a 10,000 foot view, looks somewhat incriminating. I'm fully with the whole, if you don't want to talk, don't talk. I get it. Fifth Amendment, boom. But this doesn't look too good for either of them. If I simply appear, he says, and cooperate to the extent that FINRA requires, I would be deprived of my ability to assert a constitutional guaranteed defense, he argued. FINRA declined to comment for the story, because FINRA knows what the fuck they're doing. They know what they're looking for. Smith's claims mirror other litigations, including broker Frank Black's multi-year case against FINRA, citing recent Supreme Court decisions to argue that FINRA is overstepping its authority. I'll look at this some other time, but just to have it there. Attorneys representing Black in his lawsuit against FINRA expect that a case concerning FINRA's constitutionality or a similar case that would have a direct bearing on it will reach the Supreme Court in the next several years. Wow. Whoa. Smith is asking for a temporary restraining order and an injunction to stop FINRA from requiring Smith to waive his constitutional rights against self-incrimination during on-the-record sworn testimony. FINRA requested extended time to file its response, while Chief Judge James Boasberg granted. The response is due by March 6th. Today's what? 9th. And a hearing is scheduled for March 25th. Dude, that is juicy stuff. I'm gonna try to get some notifications here for. I don't even know what the hell my shit is. Can I just make a little note here? I wonder how this works. Isn't that such a bullshit every man's kind of name? Frank Smith. What's your name, Frank Smith? Okay, me too, I guess. Let's do this all day just in case I'm, out and about and I don't have time to get on the computer. Okay. Wow. This is a credit to Patrick. I'm going to butcher it. Patrick D from wealthmanagement.com. I'm not going to say it because I'm going to disrespect him. I know it. Okay. So this gentleman here is likely either fighting for what he believes is correct, or he's trying to not incriminate himself because he did something he knew he shouldn't have been doing, or both. Both can be true. Alright, so that'll be the end of this one, but keep an eye on Frank Smith versus FINRA.